At this time of year, family lawyers get a lot of questions about how easy it will be to get a divorce in Ontario and how long it will take. People looking for a new me don't want to have their ex hanging around like an anchor. So in this episode of the Ontario Family Law Podcast, I will explain how easy and quick, or not, it will be to get an Ontario divorce. I'm John Schuman, a certified specialist in family law in Ontario. I'm also a mediator, arbitrator, and collaborative lawyer. This podcast is a companion to my book, Guide to the Basics of Ontario Family Law, which is available on the iBookstore, Amazon, Kobo, and in fine bookstores. Getting a divorce is a key part to moving on after a failed relationship. In one of the early episodes of this podcast, I explained exactly what a divorce is. The link will be in the description. To summarize, a divorce order legally ends a marriage and allows either spouse to get a divorce certificate. A divorce certificate is necessary to remarry. If you are married and you want to marry someone else, you need to get divorced first. Otherwise, you're committing bigamy, and that is a crime in Canada. If you were never married and you were just living common law, you do not need a divorce. You may need to sort out parenting issues, child and spousal support, and maybe there will be some property claims. However, many of those claims are not automatic if the couple is just living common law. Check out the previous episodes about what living common law means and what it doesn't, and how common law property is divided. There will be links in the description. Also, not everyone can get divorced in Ontario or Canada. People cannot just come here to get a divorce. To find out if you qualify to get divorced in Ontario, check out the previous episode on that. If you've been checking out the previous episodes of this podcast, you know that there are a lot of them. This is episode number 67. Please subscribe to keep up with the content and give it a like if you have found it helpful. If the spouses are married and connected to Ontario, there are a few other basic conditions that they need to meet to get an Ontario divorce. First, if there are children of the marriage, there has to be child support, and it has to be at least as much as the child support guidelines require. A judge will not grant a divorce if the children are not getting appropriate child support. And yes, the judges do ask that question, and that question is on the forms to get a divorce. And yes, several episodes of this podcast and some of my videos have explained child support. If you are tired of watching videos or listening to my podcast, get a copy of my book for more complete explanations of most Ontario family law issues. And if you are not tired of the videos and the podcast, please give them a like and subscribe. Another basis on which a judge can refuse a divorce is if the requesting spouse is not cooperating with the other spouse to obtain a religious divorce. Each spouse must do all that is within his or her power to allow the other spouse to get a religious divorce. That does not mean that a spouse has to obtain a divorce in a religion that does not allow them. But it does mean that if the religion allows divorces, each spouse must take all the necessary steps to permit the religious divorce. No religious divorce can mean no legal divorce, which means no legal remarriage. A third requirement for an Ontario divorce is that the spouses must have lived separate and apart for at least 1 year for the judge to grant a divorce. Yes, it is technically possible to get a divorce on the grounds of adultery or cruelty, but getting a divorce on the grounds of adultery means including the alleged partner in that adultery as a party to the court proceedings, which makes them much more expensive. Both using adultery and cruelty as grounds for divorce requires proving to a judge that the adultery or cruelty actually happened. That means having a trial to prove it. Going through all the steps in court to get to a trial will take longer than a year, so it will end up being faster to get the divorce on the grounds of separation of more than a year, as long as the parties agree that they have been separated for at least a year. Being separated does not mean living in different residences. It means that the spouses must have stopped living together as spouses. Often the marriage is over long before the spouses are able to move into new separate homes. Sometimes people continue to live in the same home for financial reasons. Sometimes they do it for the kids. The reason does not matter as long as they are not living together to continue their marriage, and anyone looking in would say that marriage is over. Again, the episode on how to get a legal separation in Ontario covers this in more detail, as does my book. If the spouses agree on the facts that show that they were separated more than a year ago, or one of them proves it to a judge, then the spouses can be divorced. It is important to note that a married spouse does not have to wait a year to start a court application to get the other types of orders that usually go with the divorce and are legally called corollary relief. If a spouse is not getting any support, or there are urgent parenting matters or important property matters that cannot wait, a spouse can start a divorce application in court less than a year after separation. The court will deal with the immediate issues on a temporary basis until the divorce can be granted. However, under the new family laws that came into effect in March 2021, parties must either try to resolve matters outside of court through negotiation, mediation, arbitration, or collaborative practice, or they will have to explain to the judge why using one of those quicker and often better alternatives was not possible. Again, see the episode Should You Go to Family Court for more information on that. Also, many separated spouses are pleased to hear that if the other issues are dragging on, they can get their divorce and get remarried before everything else is resolved. That is called severing the divorce, and the judge can do that if all the other requirements that I just described are fulfilled. The easiest and quickest way to get a divorce is to proceed to get an uncontested divorce. To proceed this way, both spouses must have resolved all the other issues related to the divorce, parenting, support, etc., or they must not care about them. Except for child support. The judge will care about child support. To get an uncontested divorce, one spouse prepares and then files a divorce application that seeks only a divorce and perhaps orders to which the other spouse agrees. A child support order has to be in accordance with the child support guidelines. The party making the application seeks the divorce on the basis of separation for more than a year. There is a fee for filing that application. After the application is filed, the spouse then has someone else serve the divorce application on the other spouse and files an affidavit of service with the court office showing that the application was properly served. There should be nothing in the divorce application that is offensive to the other spouse or nothing to which the other spouse objects. So the other spouse can just ignore the divorce application. This is what makes this process simple. After the second spouse has ignored the divorce application for 30 days, the first spouse can then swear an affidavit for divorce. This is a specific court form, Form 36. That form makes sure that the spouse swearing it covers all the necessary facts to get a divorce, including covering the issue of child support. If that form is not filled out correctly, the court staff will reject it. There is also a filing fee for that affidavit, but once it is properly completed and filed, along with a divorce order for the judge to sign, the matter is put in queue to be reviewed by a judge. Depending on the courthouse and how busy the judges are, it can take a few weeks to a few months for a judge to review the affidavit for divorce as well as the divorce application. It is rare for this to take more than 4 months. If the judge sees that everything is in order and all the requirements for divorce have been met, then the judge will sign the divorce order. 30 days later, the spouses can get a divorce certificate from the court. There is another fee for that, and then the spouses can get remarried. When one spouse lives outside Canada, things are a bit more complicated. There are strict rules for service of the divorce application that judges cannot change because they are governed by international laws. It is very important to follow those laws exactly, or the judge cannot grant the divorce. That may mean serving the other spouse takes longer. In most cases, it also means that the other spouse has to ignore the divorce application for 60 days instead of 30. So that can make the process take a bit longer too. It is important to make sure the other spouse will just ignore the divorce application. If the other spouse decides that he or she does not want just a divorce but wants support or property division or parenting orders, then the spouse can file an answer and seek an order from the court in addition to the divorce. If the first spouse does not agree with those orders, then the matter has to proceed through the usual family court process, which I went through in earlier episodes. If the matter goes all the way to trial, that can take years. When a divorce or matters around it are contested, then the parties either have to settle or go through the family court process. The longer the parties fight, the longer things will take. The quicker they settle, the shorter it will take. It can take several years to get to trial, and an appeal can take more than a year on top of that. Going through the legal process right to the end can easily take 3 to 4 more years. So anyone who has a new partner who wants to get married will have to find a way to settle with their first spouse, or it will be a long time to that next wedding. Using alternative dispute resolution procedures such as mediation, arbitration, or collaborative practice are almost always significantly faster than going through the family court process. So where separated spouses have a disagreement, they should seriously consider using one of those processes and then doing an uncontested divorce after they settle. That will be much faster. I described those processes in previous episodes and in detail in my book. If you need even more general family law guidance, or you need to understand Ontario family law better to make better decisions, if you need to know the best parenting options after separation, or if you need to better understand how finances work after separation and divorce, or if you need some tips on how best to make these difficult types of decisions, get a copy of my book, Guide to the Basics of Ontario Family Law. You can access it immediately on the iBook store on Amazon for the Kindle version, or you can download it for Kobo. Amazon can deliver the paperback version directly to your doorstep. You can also get a lot more Ontario family law information on www.schumanlaw.ca. Not only are there hundreds of pages of family law information and links, but there are links to get my book and links to reach my office to meet with either me or one of my colleagues. Because it is always best to get a lawyer who can give you expert advice that is specific to your situation. In addition to my website, keep up to date on family and children's law issues by liking my Facebook page, following me on Twitter at SchumanFamLaw, and finding me on LinkedIn. Of course, please subscribe to my YouTube channel and hit the notification bell to keep up to date. You can get the audio versions of the Ontario Family Law podcast on all major podcast services, including Apple Podcasts, Spotify, Google Podcasts, and many more. They are also available at www.schumanlaw.ca. Thanks for participating in this podcast. We will get together again soon.